Hi, and welcome to Help Solve the Case. Today we are talking about the Jared Bridegan case out of Jacksonville, Florida, where there are 3 defendants accused of murdering the Microsoft executive. We've got Shanna Gardner, his ex-wife. We've got Mario Fernandez Saldana, her new husband, and we've got Henry Arthur Tenon, who is accused of actually doing the deed in this case. Again, these are all accusations. This case is subject to trial, and I'm going to start going through some of the pleadings in the case. It is very fascinating to me because I used to live in the area, okay? So it's really relevant for me. And here we are talking about an order granting in part, denying in part, the defendant's motion to preclude statements. So it appears, and again, I'm not that familiar with the case. You guys know that when I pick up these documents, it's most often the first time that I've seen what's happened here. And I'm glad to have you coming along with me as I learn and as we discuss. We're not sure what happened in this case, but it looks like defendant Tenon pled guilty, attempted to plead guilty, and now has changed that and says, no, we're moving forward. We're going to move forward with trial, which is scheduled, I believe, around November of this year. And this is the first document. It's the most recent document that I was able to get my hands on, talking about statements made during the course of plea negotiations. Because if you recall, when we've gone over some of our other plea negotiations, things get said. People make statements to the state's version of the facts during that plea. If you look at what we talked about in the Broken Plea book, Bryan Kohberger, the things that Christopher Whitcomb, the retired FBI agent, what he was talking about, the lack of data or the difference in data that the state presented during that plea hearing where Bryan Kohberger pled guilty. Sometimes it's a different or lacking or whatever version of the facts specific for that plea. And then the defendant has to agree to certain things and make certain disclosures and things like that. So now that the plea is off the table, we're here with the defense. This is the judge's order, and I'll try to find the pleading if I can, but this is the judge's order talking about those statements. Okay, so let's get into it. Thanks for being here. I would love if you would like, subscribe, and share. My mission with this channel, if you don't know about it, is to donate my services in forensic genetic genealogy, cold case investigation, whatever, period, however I can help get the true answer for families that need answers, okay? And unfortunately, especially forensic genetic genealogy, that costs money. And so you being here and supporting me ultimately helps me help them wherever I need to go and whatever I need to do. So thank you. I appreciate you. Okay. So this is out of Duval in Florida. Like I said, used to live there. Go Jags. We've got this order granting in part and denying in part defendant's motion to preclude statements made during the course of plea negotiations. And they're talking about docket line 257. So I'm not sure if that's referring to specific verbiage. This was filed by the court with the judge just yesterday. So I was just thinking about the case and I said, you know what, I have to see what's going on with that. And boom, here we have something. Okay. So it says this matter comes, this is the court, this is the judge speaking. Okay. This matter comes before the court on the defendant's, quote, motion to preclude statements made during the course of plea negotiations, end quote, filed March 19th, 2026, pursuant to the Florida Rule of Criminal Procedure 3.172 and Section 90.410 Florida statutes, okay? And you guys probably know by now, with what you watch and what you like and what we talk about, that these cases are determined by the federal constitution, the state constitution, the state laws, and the rules of criminal procedure in this case, because it's a criminal matter. Okay, so all these rules and regulations that these cases, the prosecution, the defense, the judge, everybody has to act within. Okay. So it says the court held a hearing on the motion on May 13th, 2026. So pretty recently, maybe we can find that. The state presented testimony of Alan Chipperfield, assistant public defender, who represented defendant during the plea negotiations. The defendant decided to testify regarding the instant motion. Okay, they're talking about the motion to preclude. That's what it sounds like, okay? The court, having carefully considered the evidence, the record, the arguments of counsel, and being otherwise fully advised in the premises, finds and concludes as follows. Okay, they're going to go through some of the procedural history of the case here. How did we get from there to here? On February 1st, 2023, the state charged defendant by information with murder in the second degree with a weapon, conspiracy to commit murder, accessory after the fact, and child abuse. So with an information, that's not a physical arrest. It originates from the prosecution and it gets filed. Okay, that's a charging document. Every state operates a little differently. You can arrest somebody by physically arresting them. You can arrest them in Florida by information, which is the state filing the charges and getting it issued. And you can also have the grand jury and the grand jury indictment. Okay, so this was information. So this, to me, speaks volumes on the cop side, because it doesn't mean that an officer, and no offense to the officer, because I used to do this all the time, it doesn't mean that officers, when they make arrests in the field just based on the PC in their head, the information means that they more than likely sat down, especially in this type of a case, on quite a few occasions with the prosecution, the state attorney. In Florida, it's a state attorney. And they worked really hard on this case to get it to the point that the state felt comfortable in filing this information. Okay? So potentially more solid of a case. I don't know. I'm just using my practice here. Okay? My experience. 25 plus years in investigation. Okay. So that's what Tenon was charged with on February 1st, 2023. On March 16th, 2023, the defendant entered into a plea agreement with the state on a form titled, quote, plea of guilty with negotiated sentence, end quote. And most times, once somebody gets charged, they try to come in and nip that case in the bud and get a plea, okay? Because it costs money to have trials and do all this stuff and whatever. And the justice system is typically overburdened. So if they can, right, they feel they've got a good case. If they can get a plea, bing, bam, boom, they just wrap it up, okay? They would have had it wrapped up in a month and a half. Bing, bam, boom, done, okay? So, pursuant to the plea agreement, defendant agreed to plead guilty to murder in the second degree and to testify truthfully against any co-defendants. The negotiated sentencing range was 15 years imprisonment up to life. The state agreed to drop the remaining charges if the defendant testified truthfully. On the same day, the plea agreement was presented to the court, which found that the plea was freely and voluntarily entered and accepted, right? They have this back and forth in front of the court, if you've seen any of those procedures. And here they reference Exhibit A, the transcript. Sometimes people think it's very boring, but the judge has to go through all this process to make sure that everything is, as my mom would say, copacetic, right? Everybody knows what they're getting into. They know what they're being charged with, right? Like, lay it all out, okay? It says the case was deferred for sentencing. It says almost 3 years later. Okay, so he was charged. All right, so he was charged in 2023. And he entered into the plea agreement on March 16, 2023. And it was deferred for sentencing. Okay, gotcha. Okay, so what they were doing was they were saying, if you testify truthfully at Shanna Gardner's and Mario Saldana's trial, we're going to do this for you. Okay? So now that we're coming into the trial of those folks, the defendant, Mr. Tenon, has sat, okay, and then all of a sudden, 3 years later, he said, nope, not doing it. I'm not going to do it. And it says, the court granted defendant's motion on February 17th, 2026. On February 19th, 2026, the state indicted the defendant for murder in the first degree, child abuse, and possession of a firearm by a convicted felon. Remember, it sounds like they took some of those charges away, and since he withdrew the plea, they recharged him. Okay? The full force of the state. Okay? The instant motion, the motion that we're talking about right now that the judge is considering, that's what instant means. The defendant seeks to suppress any statements that the defendant allegedly made in furtherance of his plea discussions. Specifically, defendant alleges that prior to March 15th, 2023, he and Mr. Chipperfield, that's his public defender, met with prosecutors as part of ongoing plea negotiations. And yeah, stuff gets discussed. And that he may have made incriminating statements during those discussions. Further, let me back up a second. What happens there typically is there's discussions about, because it's going into a plea, defendants and their attorneys may feel they want to show the bad aspects of the case, or good, I don't know, substantial assistance is coming into my head, but that's a little different term. Goodwill, okay, right? So they're entering into these plea negotiations that they're both going to come to a win-win, okay? So it's still in the adversarial system, but it's less adversarial than it normally would be, where we're not going to say nothing, right? Okay? So, further, the defendant claims that in his sworn statement on March 15, 2023, he made incriminating statements to prosecutors under oath as part of a plea negotiation. In support, defendant argues that 1, his statements must be excluded pursuant to Section 90.410 Florida statutes and Florida Rule of Criminal Procedure 3.172, and 2, his statements must be excluded pursuant to U.S. v. Robinson. Okay, now we're going into the feds, right? Federal case citations and rulings due to the two-part test. Okay, so now the judge is going to talk about what that two-part test is here. The applicable legal standard. Section 90.410 Florida state statutes provides evidence of a plea of guilty later withdrawn, a plea of no contest, or an offer to plead guilty or no contest. That's what nolo contendere means. That's Latin for no contest. The contender, they're not going to contend against it, right? So no contest to the crime charged or any other crime is inadmissible in any civil or criminal proceeding. And they got it underlined here. Evidence of statements made in connection with any of the pleas or offers is inadmissible, except when such statements are offered in a prosecution under Chapter 837. Now, it doesn't look like we have a citation under 837. Not sure what that's about, but apparently it doesn't apply because the judge didn't include it. Remember, this is the court writing this document. Similarly, Florida Rule of Criminal Procedure 3.172 subsection I provides, except as otherwise provided in this rule, evidence of an offer or plea of guilty or nolo contendere, no contest, later withdrawn, or of statements made in connection therewith is not admissible in any civil or criminal proceeding against the person who made the plea offer. Okay? The Florida Supreme Court has explained that Section 90.410 and Rule 3.172 subsection I were, quote, adopted to promote plea bargaining by allowing a defendant to negotiate without waiving Fifth Amendment protection, end quote. The judge cites Grover v. State, okay? They're talking about so that they can negotiate in good faith and have a quid pro quo. You give me this, I'll give you this, like let's work it out. The win-win that I mentioned. The Florida Supreme Court further noted that these provisions were intended to promote, quote, free and open discussion between the prosecution and the defense during attempts to reach a compromise, end quote, that win-win. The judge references U.S. v. Davis, which neither Section 90.410 nor Rule 3.172 subsection I require that a plea bargain be completed or that a written agreement be signed before negotiations can be excluded from evidence. So it doesn't have to get all the way to the finish line. Okay? Nunez v. State citing Richardson v. State, both Florida cases, okay? In determining whether a defendant's statement should be admitted, courts should first apply the plain meaning of Section 90.410 Florida statutes and Rule 3.172 subsection I, the Rules of Criminal Procedure. And if that analysis doesn't resolve the issue, then they could go to Robertson and then Calabro v. State. In Robertson, says the judge, the Fifth Circuit held that courts should consider the totality of the circumstances in each individual case, focusing on two factors. One, whether the defendant had a subjective expectation in engaging in plea negotiations, and two, whether that expectation was reasonable under the circumstances. Okay, and they're quoting Robertson. At the hearing, Mr. Chipperfield, again, this is the judge telling us what happened. Okay, because he or she, not sure if it's he or she, is going to frame their ruling. So Mr. Chipperfield, they say here, has been a criminal defense attorney for over 40 years and is a very experienced criminal trial attorney. Both sides agreed to his level of experience. Mr. Chipperfield was appointed to represent the defendant. Mr. Chipperfield testified that during his representation of the defendant, he was negotiating a cooperation agreement with the state. See, that's kind of like substantial assistance, if you know what that is. Substantial assistance, you usually see that in like drug cases and stuff like that. But, okay, cooperation agreement, quid pro quo. You do this for me, I do this for you. What do you want here? I need this to give you this. Okay. Mr. Chipperfield, defendant, and the state met multiple times, and he exchanged emails with the state about negotiations. Yes, happens all the time. Candid conversations. On February 17th, 2023, a plea negotiation conference, parentheses, the quote, proffer meeting, end quote, and parentheses, took place between Mr. Chipperfield, defendant, and the state, during which defendant gave a proffer for the purposes of plea negotiations. Okay, here's what I'm willing to give you. If you give me this, what are you going to give me in exchange? During the proffer meeting, it was explained to Mr. Chipperfield and the defendant that anything defendant said could not be used against him in light of the plea agreement, plea negotiations. So let rip, right? After the proffer meeting, think about proffer. See, it's got the PR. Proffer, it's like an offer, okay? The parties negotiated more definite plea terms. From February 17 to February 24, 2023, Mr. Chipperfield and the state exchanged emails about the terms of the plea negotiation. Apart from court costs, all terms of the plea were agreed upon by March 1, 2023, when Mr. Chipperfield had a chance to speak with the defendant. The attorney always has to relay anything that the state is offering to the defendant if the defendant isn't present. Okay, then the defendant makes his decision. The terms agreed upon by March 1st, 2023 were the same as those of the written plea agreement that the parties executed on March 16th. Okay, so they agreed, they brought it before the court, and they formalized it. But it didn't fully come into effect because the defendant had conditions. He had to truthfully testify, okay? So it wasn't done because he hadn't fulfilled all of his obligations for then the state to fulfill their obligations. It was on the table, so to speak. On March 15th, 2023, defendant gave a sworn statement to the prosecutors in the presence of law enforcement. The purpose of the sworn statement was to memorialize under oath what defendant would testify against his co-defendants in order to comply with the terms of the plea agreement requiring defendant to testify truthfully in the case. In the March 15, 2023 meeting, Mr. Chipperfield testified that no one advised defendant that anything he said during the sworn statement can and will be used against him. Okay, so let's talk about this for a second. He's in custody. Miranda applies because he's going to give incriminating statements. It sounds like he was not read Miranda. And that's because those statutes and the rules are coming into play, I'm guessing. Okay? This is what the judge is saying. Conversely, no one advised defendant that the sworn statement could not be used against him because it was pursuant to plea negotiations. Mr. Chipperfield stated that he believed the sworn statement could be used against defendant if defendant decided to back out of the plea agreement. Admittedly, Mr. Chipperfield did not consider that a possibility. So that's interesting. Is there a disclosure? Because I'm not an attorney. Is there a I know gabs about Miranda, but is there a disclosure that is supposed to be read with what the judge is saying here during this plea disclosure? I'm not sure again here exactly about the language. If Mr. Chipperfield should have required something or whatever. B, defendant's testimony. The defendant testified that when he gave the sworn statement on March 15th, no one told him it could be used against him. Likewise, no one told him it could not be used against him. Defendant did not ask his attorney whether the sworn statement could be used against him if he withdrew from the plea agreement. Additionally, the defendant testified that when he gave the sworn statement on March 15, 2023, he believed he was speaking to the state for the purposes of a plea agreement. Defendant stated that at the time he gave the sworn statement on March 15, 2023, he always intended to withdraw his guilty plea at some point in the future. That's interesting, isn't it? All right, now we have the findings of fact and conclusions of law. Statements at the proffer meeting. Mr. Chipperfield's credible testimony establishes that defendant gave a proffer at the proffer meeting on February 17, 2023 for the purposes of plea negotiations. And at that meeting, it was explained to Mr. Chipperfield and defendant, okay, this is what the judge is saying, that anything defendant said could not be used against him in light of the plea negotiations. Okay, so I don't know what happened there, but the judge is saying that's what happened. Under these circumstances, and considering the state made no argument to the contrary at the hearing, there is no question that any statements defendant made at the proffer meeting are inadmissible against defendant in this criminal proceeding pursuant to Section 90.410 and Rule 3.172I. Accordingly, the motion is granted in part as to any statements defendant made at the proffer meeting. Okay, because maybe the disclosure was made at the proffer meeting. Maybe that's the requirement there. Not sure. We'll keep going. The sworn statement. The arguments at the hearing centered on the admissibility of defendant's sworn statement to prosecutors in the presence of law enforcement on March 15th, 2023. Okay, so the proffer meeting was February 17th, 2023. And then he made a sworn statement on March 15th, 2023. The judge says, ultimately, both the plain meaning analysis of Section 90.410 and Rule 3.172I and the Robertson analysis, that's the U.S. case, require the same outcome. The sworn statement is admissible. Oh, goodness. What changed? What changed? Okay. Now, did he get his Miranda? Like, this is so interesting to me. Is it interesting to you? Like, this is interesting. So one is good and one is not. For purposes of the plain meaning analysis, the controlling case is Groover. In Groover, the Florida Supreme Court held that a sworn statement made in fulfillment of a negotiated plea bargain, as opposed to a statement made to induce or enhance negotiations, is not a statement made in connection with a plea for the purposes of the statute or the rule, even if the defendant has not yet entered his plea in open court. So if you're entering into plea negotiations and you agree to make a statement, a sworn statement, the sworn statement can come back to bite you, even if the plea negotiations can't. So why would you make a sworn statement? Should Miranda have applied? I don't know. This is interesting. Okay. So it says, see Groover. The Florida Supreme Court reasoned, okay, maybe they're going to explain it to us, reasoned that when an agreement has been reached, further statements cannot be made in the expectation of negotiating a plea, and the policy of fostering frank discussion between prosecution and defense does not extend protection to statements made in fulfillment of an agreed upon bargain. Wow. Okay. So I think what they're saying there is you can say whatever you want to negotiate, but once you've negotiated, anything after that is fair game. Wouldn't that seem what they're saying? Here, the evidence clearly indicates the admissibility of the statements. The proffer meeting statement is clearly the type of statement the statute, rule, and law seek to protect. The difference is notable. When the terms of the negotiations were finalized, the sworn statement made in the presence of law enforcement is a, quote, statements in performance, end quote, of the plea agreement. So how do you, if you agree to make a statement, but then the statement incriminates you, but you have to fulfill it, not sure here. What do you guys think? Like, it's a little bit distressing. It's a little bit confusing. The court places its reliance on the testimony of Mr. Chipperfield and finds it to be credible. His testimony establishes that on March 1st, 2023, 2 weeks before defendant gave his sworn statement, the parties had agreed to the terms and negotiations had concluded. Moreover, Mr. Chipperfield's testimony establishes that the purpose of the sworn statement was to memorialize what the defendant would testify if called as a witness against his co-defendants. The plea agreement required the defendant to testify truthfully against any co-defendant. So I guess the intention was that your intention is to move through with this plea agreement. And so anything that you would have said and admitted in the sworn statement in the plea agreement wouldn't have mattered because you would have gotten your plea. I'm guessing. Yeah? Okay. The sworn statement was one step in the performance portion of the plea agreement. Thus, like in Groover, defendant's sworn statement was done in fulfillment of the agreed to bargain as opposed to being done to induce or enhance negotiations. The court finds that the sworn statement is not a statement made in connection with a plea for the purposes of Section 90.410 Florida statutes and Rule 3.172I Florida Rules of Criminal Procedure. Therefore, the sworn statement is not entitled to protection under the statute or rule. So that's interesting, huh? Let's go back to see exactly what the language is in that statute. Evidence of a plea or guilty, later withdrawn, plea of no contest, or an offer to plead guilty is inadmissible. Evidence of statements made in connection with any of the pleas or offers is inadmissible. I don't know what 837 says. I mean, that's kind of vague, right? Where are we? Okay. The Florida Supreme Court's subsequent decision in Wainwright v. State, and that, I know Wainwright, reinforces this conclusion. In Wainwright, the Florida Supreme Court affirmed admission of incriminating statements made over an 11-day period following the parties' agreement that the state would not seek the death penalty, holding that the statements were in the, quote, performance stage, end quote, of the agreement. The court explained that by the time the defendant made the incriminating statements, quote, the agreement between the parties was a fait accompli. Okay, it was a done deal, end quote. And there was, quote, no need for free and open discussions, end quote. And, quote, no public policy would be furthered by suppressing such statements, end quote. The Wainwright statements were admitted, notwithstanding that no formal plea had been entered when the statements were made. The court focused on whether an agreement had been reached, not on whether the plea had been formally entered, whether it was complete. Likewise, the Groover court relied on U.S. v. Sterling, which is a U.S. case, in which a defendant testified before a grand jury after reaching a plea agreement, but before entry of his plea, and then withdrew the plea. The Second Circuit held the testimony admissible because, quote, the plea agreement had already been reached, ... The negotiations were over. All the defendant had to do was live up to his end of the bargain. His failure to do so justly exposed him to prosecutorial use of his grand jury testimony, end quote. The factual posture of Sterling is material indistinguishable from the case at bar. The court rejects the defendant's argument that his sworn statement remains protected because his plea had not yet been formally entered into open court on March 15, 2023. And this is interesting to me. So do we think here that the defendant is responsible for his own jeopardy, I guess we could call it here, because he was supposed to take the plea, kind of like Miranda, where you get read your right to remain silent, and if you don't take it, that's on you. But at the same time, when you thought you were going to take the plea, and then you agree to do something, but then you don't want to take the plea, I guess we could liken it to if you have Miranda read to you and you decide to speak anyway, like you can't come back and say, I should have shut up, so you need to suppress those statements. I don't know. It's interesting here, okay? Because he now has a duty, right? He now has a duty to speak against himself. Let's keep going. So the court finds that the sworn statement is not entitled to protection under the Robertson test. And the Robertson is the case. We talk about precedents, how precedents are used to make decisions moving forward. Although the defendant testified that at the time of the sworn statement, he believed he was speaking to the state for the purposes of the plea agreement. And we looked at that language, and that language is not so clear to me, right? So he believed he was speaking to the state for the purposes of the plea agreement. It is unclear to the court whether he believed he was speaking to the state in fulfillment of the plea agreement or for purposes of plea negotiation. What do you think? Such testimony by itself is insufficient to establish that the defendant had a subjective expectation of engaging in plea negotiations at the time of the sworn statement. As the Fifth Circuit cautioned in Robertson itself, quote, an accused's subsequent account of his prior subjective mental impressions cannot be considered the sole determinant factor. Otherwise, every confession would be vulnerable to subsequent challenge, end quote. What are they saying there? That everybody would just get away with it? I'm not sure. Whereas here, the record does not disclose a contemporaneous expression of an intent to pursue plea negotiations, the court, quote, must focus searchingly on the record to determine whether the accused reasonably had such a subjective intent, examining all of the objective circumstances, end quote. So could it be that when you get asked to do the sworn statement, do you ask for Miranda, or do you ask or make mention that this is part of the plea negotiations? Because here's a question, is it still a negotiation if it's not done? Right? Like if you have a contract with somebody to mow your lawn and they only mow part of the lawn, it's not done. Right? They call it in civil specific performance. So at that point, and again, I'm getting legalese here, and that's in the civil world, specific performance. So if he gave his confession or his statement, and then the state needed to do their thing, but the state, the trial hadn't happened, so the state didn't have its opportunity to do its thing. The state could have not done its thing. So is that specific performance? Because specific performance had not concluded. But then with the defendant, his specific performance was to testify. I don't know. It just wasn't complete. So this is very interesting to me. Even assuming arguendo that the defendant had a subjective expectation of engaging in plea negotiations at the time of the sworn statement, okay, kind of what I'm talking about, that expectation was unreasonable under the circumstances. Although defendant did not receive an express warning, Miranda, before he gave the sworn statement that it could and would be used against him if he backed out of the plea. Now, how does that happen? Because he's in custody and he's incriminating himself and he's being forced to do so under the plea agreement. Where's my lawyers? Where's my lawyers? Right? All good conversation here. The circumstances surrounding the sworn statement were markedly different than those surrounding his earlier proffer. Unlike at the proffer meeting, the defendant was told anything he said could not be used against him. See, I'm so used to saying that can be used against you. I can't get the not out. Okay. Moreover, unlike at the proffer meeting, law enforcement was present for the sworn statement. That's a big hint. Okay. The badges are there. Presumably to fact check and to witness if perjury charges were pursued if the defendant changed his testimony. I don't know. Maybe you could still do that with a prosecutor. Under these circumstances, it would have been unreasonable for the defendant to expect that he was engaging in plea negotiations at the time of the sworn statement. I don't know. That language is kind of vague. I don't know. What do you guys think? Additional objective circumstances confirm that any belief that defendant remained in active plea negotiations on March 15, 2023 was unreasonable. This is the judge's determination, remember. The prosecutor's preamble to the sworn statement, okay, let's see what it said, informing the defendant that, quote, tomorrow you're going to enter a plea deal, end quote, and that, quote, no one has promised you anything other than what we've talked about, 15 to life on that charge, end quote, reflects by defendant's own characterization of the record that the parameters of the agreement had been settled. So right before he made the statement, tomorrow you're going to enter a plea deal, I don't know. What do you think? The written, quote, plea of guilty with negotiated sentence, end quote, form, I think that's form, defendant executed the next morning contains terms identical to those recited the day before. No one has promised you anything other than what we've talked about. I don't know. I'm uncomfortable with that. I don't know. But I'm not a lawyer. I'm uncomfortable with that. What about you guys? It contains identical to those recited the day before. Mr. Chipperfield's testimony establishes that the parties had agreed to those same terms by March 1st, 2023, 2 weeks earlier. On these objective facts, it is clear that the sworn statement was made after negotiations ended, and it was not a vehicle to reach one. Wow. So it says, based on the foregoing, ordered and adjudged that defendant's, quote, motion to preclude statements made during the course of plea negotiations, end quote, filed March 19th, 2026, is granted in part as to any statements defendant made at the proffer meeting on February 17th, 2023 are excluded, and B, denied in part as to the sworn statement defendant gave on March 15th, 2023 is admissible. Oh, jeopardy. Talk about jeopardy. Man, this is interesting to me. What do you think? And I'm sure he gave a substantive statement. Let's go back to that. I would love for some attorneys to weigh in. Are they going to appeal this? This just came down. Okay, here it says. Evidence of a plea of guilty later withdrawn. A plea of no contest or an offer to plead guilty or no contest is inadmissible in any civil or criminal proceeding. It says evidence of a plea of guilty. Evidence of statements made in connection with. Like, how are you reading that? Evidence of statements made in connection with any of the pleas or offers is inadmissible. except as otherwise provided in this rule. This is 3.172I. Later withdrawn or statements made in connection therewith is not admissible. Like, in connection therewith, it was a requirement. Like, is that connection? I don't know. Where's my lawyers? That just seems like, because it doesn't say negotiations only, does it? It says made in connection therewith. It doesn't say made to negotiate, right? See, those where those case laws and those precedents come in. I'm wondering if this is going to be a precedent. They're going to go after precedent to try to set precedent here. Very interesting. What do you guys think? Let me know below. Okay, I'm going to search for more documents on this case. I'll see. I don't know if the sworn statement is out or what is out. And I would love to find, if I can find, I may have to go in the court docket. I want to find what the defense is arguing, double jeopardy or some Miranda type. I don't know what they're arguing. But this is, right now, this is the judge's decision. And can they appeal it now? Or is the trial going to have to go forward? And what kind of evidence did he submit in this sworn statement? Okay, so how much of the case is built on that sworn statement? Regardless of whether you're on one side or the other, this is about due process in the Constitution and self-incrimination here. Leverage, coercion, things we've been talking about in the cases. So I would love to know your thoughts. Okay, I will catch you on the next one. Thanks for being here. I really appreciate all the comments. Your liking, sharing, and subscribing helps me build this channel, which helps me do more for others, help solve these cases, and get the word out there. Okay, see you later. See you on the next one.